I call the hearing to order. This is the hearing that we have captioned Big Fixes, Big Tech. And this, I would add, is the first hearing of the Senate Antitrust, Competition Policy and Consumer Rights hearing in the 119th Congress. I also want to begin by welcoming our new ranking member, although it's a somewhat ironic welcome given that he's not able to be with us at the moment. He is on the Senate floor, but I welcome him nonetheless as the ranking member. And I also welcome my friend and colleague, Senator Welch, who has graciously agreed to fill in for Senator Booker today for purposes of this hearing. And of course, welcome the other new members of the subcommittee, including Senators Schmidt, Britt, Moody, and Schiff. That somehow sounds like a line in a song. There's a rhythmic quality to it. Schmidt, Britt, Moody, and Schiff. Bobby, Robbie, Mickey, and Mike. If I like the girl, who cares who you like? That it's a song from the 80s. It's not a very good song, but it reminded me of that. This subcommittee has a long history of examining anti-competitive conduct by various actors within our economy, including more recently by big tech firms. Today's hearing continues that part of our important work. And the focus of this hearing in particular involves identifying effective solutions for big tech's anti-competitive conduct. We cast a pretty wide net in preparing for this hearing. We invited Google to participate as a witness. Google declined the invitation. Now, for too long, a handful of technology giants have dominated certain key sectors of our economy, limiting innovation, harming small businesses, and gatekeeping information. Federal and state antitrust enforcement actions against big tech are continuing to proceed in the courts. Nearly 5 years ago, President Trump's Department of Justice sued Google for monopolizing the online search market. The court found Google liable and will hold a remedies hearing in a few weeks. After the remedies phase, there will, of course, likely be a series of attempts to address the outcome one way or another through the appellate process before that case is finally resolved. Additionally, the Department of Justice sued Google for monopolizing the ad tech market. Google has what's been referred to as a trifecta of monopolies, owning the marketplace and the tools used for buying and selling ads, positioning itself simultaneously to be the buyer, the seller, the agent, the broker, and filling in a number of other roles. Although the trial concluded last year, the decision in that particular case is still pending before the court. The Federal Trade Commission, of course, sued Facebook in 2020 to unwind some of its prior acquisitions in the social media space. And that particular litigation is moving even slower, with the trial finally scheduled to begin this month, almost 4.5 years after the filing date. All the while, these alleged monopolists continue operating with few restrictions, reaping monopoly profits year after year. President Trump has long recognized the inherent danger posed by big tech's unchecked power to the extent it remains unchecked. When President Trump nominated Gail Slater as Assistant Attorney General for the Antitrust Division at the Department of Justice, the president emphasized that big tech had, quote unquote, run wild for years. In the process, stifling competition, cracking down on the rights of many Americans, as well as the opportunities that might be available for what might be referred to as little tech, or at least everyone in tech outside of very, very big tech. President Trump also appointed Andrew Ferguson as FTC chairman more recently, and Chairman Ferguson previously served as the Solicitor General of Virginia, who joined the Department of Justice's ad tech lawsuit against Google. As we discuss legislative alternatives, we must first revisit some of our prior efforts. In the last Congress, I introduced the America Act, which received broad support, including from then Senator, now Vice President and President of the Senate, J.D. Vance, as well as a number of my Democratic and Republican colleagues, making this bill truly bipartisan. Digital advertising is, in many respects, the lifeblood of countless small businesses and large ones, but it can make all the difference between sinking or swimming among small business in particular. Yet dominant platforms act simultaneously as buyers, sellers, brokers, platform owners, and so forth, setting their own rules and charging inflated, some would say rent-seeking fees. A former senior director at Google, who led billion-dollar ad tech teams, once asked whether there was a deeper issue with a single firm owning the platform, the exchange, and a huge ad network. He likened it to Goldman Sachs or Citibank owning the New York Stock Exchange. And that is precisely what's happening in the digital advertising market today. The America Act would prohibit tech giants from controlling multiple parts of the ad tech stack, and it reflects the principle that structural remedies solve the foundational issues and then, by doing so, allow the free market to work as it was always intended to. Whereas regulatory and merely behavioral remedies require ongoing oversight, very often with mixed results or without the results generally that we want. Litigation is, of course, a lengthy process, and even successful cases can result in narrow, firm-specific remedies. Congress, of course, has the opportunity to pass solutions to unlock competition across tech platforms, ensuring that American consumers can and will benefit from competition. Competition is especially important in this space, given that technology opens up to us a lot of efficiencies that otherwise wouldn't be there. One of the things that can help keep inflation in check, even amidst other circumstances that have caused inflation to spiral out of control, often hurting America's most vulnerable, its hardworking, poor and middle-class families the hardest. And so the efficiencies, the productivity that can be achieved through technology is there to benefit the American people generally. That is, if it is allowed to work within a free market system. That's one of the reasons why competition policy and our system of antitrust laws designed to protect competition rather than competitors are so important. Now, under a new Congress and a new administration, the time has, of course, come for Congress to act. If we fail to act, not only will competition and consumers likely suffer, but big tech companies will continue to perpetuate bias and censorship against those they disfavor, and competition itself will be thwarted, depriving consumers of the increased prices, the diminished prices and increased quality that inevitably accompany competition, wherever it's allowed to thrive. I want to thank our witnesses in advance of their testimony for joining us today for this part of our discussion, and very much look forward to what each of you have to say. I'll turn it over now to Senator Welch.
Thank you very much, Senator Lee, and I really, we all do appreciate the focus you've had on competition and how important that is. Senator Booker is very excited about co-chairing this, being the ranking member on this committee with you, and sends his regrets. I did want to just say a couple of things. This big fixes for big tech is incredibly important as an antitrust issue, because the antitrust is always about the concentration of power, and then the pricing power that the dominant players get, and then the folks in everyday America who are more than ever struggling with affordability questions. At the end of the month, folks in Utah, folks in Vermont are just looking at their checkbook and wondering how are they going to do it and which bills are they going to have to postpone until next week. And that includes, by the way, a lot of things that are related to tech. So this is a very timely hearing, and I'm very confident we're going to make some progress with your leadership and the leadership of Senator Booker. I did want to address one thing that has disturbed me, and it's what's happened at the FTC. You know, that is an organization that is about protecting against unfair competition, and we need 5 people on it, and 2 have been fired. They happen to be the Democrats. There's always been a 5-person FTC, 3 of the majority party and 2 from the minority party, and it shifts back and forth. And I just want to express my dissatisfaction and dismay at that, because that FTC does things that is absolutely helpful to protecting consumers from this abuse of pricing power. We had, with this FTC in 2022, they stopped a consolidation of Kroger and Albertsons, which most economists thought was going to raise food prices for those folks in Utah and those folks in Vermont. They brought an administrative complaint against the prescription benefit managers. And it's such a ripoff what's happening to everyday consumers and employers, by the way, who pay a lot of money for employer-sponsored health care, and they have no visibility, no transparency into how much people are getting charged. And it hurts small employers and big employers in your state and mine. And the FTC was on that case. And also, they are on another matter that is near and dear to Vermont farmers, the right to repair. I mean, how in the world is it that you can't, if you own a tractor, repair it yourself? You've got to go in and pay a lot of money because it's now all on computers. And the FTC was looking into that. And I think farmers in Florida, farmers in Utah, farmers in Illinois, if they can figure out how to repair it themselves, they shouldn't get ripped off by the not having the right to repair. And I know there's some bipartisan support for that. But we had an FTC. We have an FTC that was on all 3 of those cases. So my view, it's really important that we get that at full strength, and I'm very disappointed that we have an administration that would fire 2 in midterm. But with that, let's get on with hearing from the people who know what they're talking about. And that's them, more so than us a lot of the times. Thank you very much.
Thanks so much, Senator Welch, and we're grateful to have you here today and filling in for Senator Booker, and look forward to a report back from him on how his knees, his feet, and his back held out during his grueling process.
Well, he's got football training. So.
Indeed, yeah. All right, I'll now briefly introduce our witnesses before swearing them in. We've got Professor Rory Van Loo, who was a professor at Boston University School of Law. Gary Tan is the CEO of Y Combinator. Jason Kint is the CEO of Digital Content Next. Camille Bazbaz is the Vice President of Public Affairs at DuckDuckGo. And Morgan Harper, sorry, I got out of order there. And Morgan Harper is the Director of Policy and Advocacy at American Economic Liberties Project. At first, I thought we had mismatched the names, and I just got them out of order. All right, with that, I'll swear in the witnesses, and if you'll please stand and raise your right hand. Do you swear or affirm that the testimony you're about to give to the subcommittee will be the truth, the whole truth, and nothing but the truth? So help you God. Thank you. Let's just indicate for the record that all witnesses answered audibly in the affirmative, and thanks again for being here today. All right, so we'll start with you, Professor Van Loo, and then we'll move over to your right, my left, in order for your opening statements. You may proceed.
Chairman Lee, Ranking Member Booker, and Welsh, members of the committee, thank you for inviting me here today to speak. My name is Rory Van Loo, and I'm a law professor at Boston University. But before that, I was a member of a family growing up that was on a very tight budget. And I watched my father, a small business owner, electrician, who in his 70s is still out there in the field pulling wires and drilling holes alongside his 2 employees to make the transition to digital advertising. I also, in a past life, was a strategy consultant to multinational CEOs, helping them to grow their business. And in my research, I've focused over the past decade on big tech. I look for legal reforms that make sense for small businesses and large businesses, laws that would lower consumer prices while strengthening the economy. We especially need such laws right now because of the precarious state of the economy and the growing evidence that many of the prices we're paying are well above what would be expected in more competitive markets. Big tech influences the prices that we pay in subtle ways. For example, if Google uses monopoly power to charge higher prices for advertising to retail stores or small businesses like my father's, they may have no choice but to pass it on to us. And online retailers can raise prices in subtle ways in their search results. In a prior study, preliminary study with Nikita Agarwal, we found that the first item returned by Amazon in the search results was 24% more than the best deal on that first page, buried in the 17th slot, down where few consumers look. These are invisible taxes that we all pay when competition falls short. The good news is that this committee has the power to unlock tremendous economic gains by making markets more transparent and competitive. I'm going to discuss 3 key architectural design principles in your bipartisan America Act that can be applied more broadly as a legislative blueprint for the digital economy. The first principle is seeking strong solutions to address abuse of monopoly power. Our government has often been too afraid to break up monopolists. Government officials and academics have often said breakups are like unscrambling eggs. They say it's too messy, if not impossible. But large businesses like Hewlett-Packard and eBay, PayPal break themselves up voluntarily all the time. Government breakups of Standard Oil in 1911 and AT&T in 1984 show that big breakups can be followed by strong growth and innovation. It's not always the answer, but for decades, the message to CEOs has been, if you build a monopoly by buying competitors, you get to keep it. That needs to change. The America Act sensibly does not let the fear of breaking up Google and Facebook stop it from outlining a bold vision for digital advertising competition. A similar willingness to pursue strong remedies applied carefully needs to be on the table for other efforts to dislodge abuse of big tech monopoly power. Stopping abuse of monopolists is important, but it's not enough for full competition. If customers can't tell which business is offering the best deal, then businesses won't have the right market pressures to innovate and charge competitive prices. Big tech is currently free to put its own interests first without customers' knowledge. The America Act addresses this problem and illustrates the second key design principle by requiring digital advertising brokerages to put their customers' best interests first. One could imagine similar requirements of other big tech companies like Amazon in its search results. These legal requirements would move big tech towards the kinds of heightened duties required of doctors and stockbrokers, among others. The final principle is that access to information in marketplaces is essential for full competition. Yet too often, big tech companies block key access, even to basic information. The America Act responds by mandating fair access to both digital advertising exchanges and information. Access mandates have lowered consumer prices in other countries and have the potential to help shoppers find the best deals on Amazon or help teens avoid toxic social media content on Instagram, especially with the help of third-party AI assistants. In conclusion, I encourage you to pass the America Act and then apply a similar blueprint to other spheres of big tech. More than a century after Congress passed strong antitrust laws and Teddy Roosevelt challenged monopolies, students still learn about it in school. We're at another one of those historical moments. Taking strong action to improve competition not only makes economic sense, but as a bonus, would send strong messages that our leaders in government are not afraid to stand up for the people in the face of powerful businesses. That message would resonate immediately, widely, and for generations to come. Thank you.
Thank you, Professor Van Loop. Mr. Tin.
Chairman Lee, Ranking Member Booker, and members of the subcommittee, thank you for the opportunity to testify today about Restoring Competition and Innovation in the Digital Economy. I'm Gary Tan, President and CEO of Y Combinator. At YC, we partner closely with promising early-stage companies, providing mentorship, education, and valuable connections. Since 2005, Y Combinator has invested in over 5,000 companies when they were just one or two people in the proverbial garage, including Airbnb, Dropbox, Stripe, Reddit, Instacart, DoorDash, and Coinbase, creating thousands of jobs and products beloved by millions. The YC motto reads, "Make something people want. Our companies strive daily to embody this principle." We stand at a critical juncture. The unchecked concentration of power in big tech has severely limited innovation, harmed consumers, and undermined America's global competitiveness. I'm here today representing Little Tech, the startups, innovators, and entrepreneurs whose voices are rarely heard in Washington, but who hold the key to America's technological future. Their potential is consistently hindered by dominant incumbents. To illustrate, I'll share 3 examples from YC startups. First, consider API access. An API, or Application Programming Interface, is a technical gateway that allows startups to integrate and build upon platforms, enabling innovative solutions to reach consumers. One YC startup created cutting-edge technology capable of detecting deepfake fraud, such as fraudulent calls targeting elderly parents. Despite its potential to address an urgent societal issue, this startup was forced to pivot because it was denied essential API access by dominant platforms. Second, interoperability, meaning the ability of different technological systems and services to seamlessly communicate and work together. That's critical. Beeper, another YC startup, aimed to simplify messaging across platforms, offering genuine consumer choice by breaking down the green versus blue bubble divide for text messages. Imagine an interoperable messaging client powered by LLMs, advanced artificial intelligence capable of understanding and generating human-like text, capable of intelligently detecting and warning users against sophisticated scams. Unfortunately, restrictive practices by companies like Apple effectively shut Beeper out of competition, limiting consumer access to these potentially transformative solutions. Third, dominant firms continually engage in harmful self-preferencing, exemplified clearly by Siri. Despite serving over 1 billion people globally, Siri remains embarrassingly behind, often providing outdated or nonsensical responses. Apple's monopolistic control has stifled Siri's ability to integrate cutting-edge generative AI technologies, leaving consumers with an inferior product. Consumers get transformative technology years later than they otherwise could because entrenched monopolies consistently pull the ladder up behind them. This abuse of dominance directly contributes to the decline of innovation and undermines America's technological leadership. The failure of the FTC to bring an enforcement action against Google's egregious forms of self-preferencing in 2012 sent a message to every gatekeeper that it was open season for self-preferencing. As a result, the web has become less open. Today, most traffic that starts on Google terminates on Google rather than winding up on the open web. History offers clear lessons on effective remedies. The landmark Microsoft antitrust case demonstrated how mandated open API access and prohibitions against exclusionary agreements can foster competition. Google's Chrome browser emerged precisely because Microsoft's monopoly was curtailed. Therefore, I strongly support rigorous enforcement of existing antitrust laws when dominant platforms engage in egregious self-preferencing or block reasonable interoperability. Congress must pass legislation providing antitrust enforcers with targeted tools to address these issues effectively. Specifically, policymakers should consider mandating open API access, require dominant firms to provide open APIs, empowering startups to develop groundbreaking innovations, enforcing interoperability requirements, ensure major platforms offer interoperability, giving startups and consumers meaningful choices and access to advanced technologies. And finally, third, limiting self-preferencing. Adopt clear restrictions preventing dominant companies from artificially prioritizing their own products over competitors. Consumer choice must be protected. Ultimately, the unchecked dominance of large tech companies jeopardizes America's economic strength and technological leadership. Vibrant competition, transparency, and open markets are essential for innovation and consumer protection. Thank you, and I look forward to your questions.
Thank you, Mr. Ten. And Mr. Kint.
Chairman Lee, Presiding Member Welch, and members of the subcommittee, thank you for the opportunity to testify today. I'm Jason Kint. I am CEO of Digital Content Next, a trade association representing premium publishers. I've spent my entire career in digital media, first building media businesses in the early days of the web in the 90s, to now working more recently to protect the future of information, news, and entertainment online. I care deeply about these issues and how we ensure a free and plural press into the future. Our members include companies you know well: the New York Times, Wall Street Journal, Fox News, Paramount, MLB, Vox, and many others. Over 60 in total, thousands of brands. They make high-quality content that individuals rely on and trust, depending on their preferences. But these companies are up against enormous odds in today's digital marketplace. I first testified about these issues several years ago, right here before the Senate Judiciary Committee, warning that Google and Facebook were gobbling up most of the growth in digital advertising. Back then, it still felt like a hypothetical to many, but it's not hypothetical anymore. Since then, we've seen lawsuits filed and verdicts handed down, both from judges and from juries of everyday Americans, that confirm exactly what we feared. Let's talk about Google. Today, they don't just compete in the advertising market, they run it. They control the tools the advertisers use to buy ads, they control the tools that publishers use to sell ads, and they control the exchange in the middle where those ads are auctioned off in real time. It is like they're the referee, the player, and the scoreboard operator all at the same time. And it's not just theory. In court documents, Google compared itself to Goldman Sachs, owning the New York Stock Exchange. As Chair Lee mentioned, they weren't even hiding it. It was in their emails. We've seen evidence they gave themselves secret last look advantages, that they were rigging auctions to hit their profit targets, and that they shifted revenue shares in auctions without warning, even calling it, quote, shaking the cushions in order to make their quarterly earnings. Google's global managing director of publisher platforms even admitted that the high capture of publishers' revenue only happens because of the value and because they control the unique demand on the buy side. They're able to capture more of that value on the publisher side. I can't think of a better testimonial for the America Act. Dominance on the buy side, being able to squeeze out more profit from the publisher side. When the DOJ and state AGs started asking questions, Google deleted internal messages and allowed them to continue to be deleted. That's not just concerning, it's outrageous. And that's why Judge Donato sanctioned them during the trial. They've already been found liable for search ad monopoly abuse. And they lost their App Store case for unanimous jury in California. So this isn't just speculation, it's now on the record. And meanwhile, local news outlets and publishers have been suffocating under the system for more than a decade. I want to recognize the strong bipartisan leadership here. Senator Blumenthal had worked with Senator Blackburn to do important work on kids' online safety and continues to do. Senator Hawley has been a consistent voice on market power and data. Senator Klobuchar previously led this committee and has fought relentlessly to restore competition. Senator Moody, when you were AG, I remember being at the steps of the Supreme Court as you led the charge on antitrust enforcement. I was captured by your remarks that day. And Chairman Lee, I want to thank you in particular for introducing the America Act. It's a smart, targeted bill. It doesn't try to break up companies or tell them how to run their products. It doesn't pick winners and losers. It just says if you're running the marketplace, you shouldn't be allowed to secretly play all sides of the deal. That's a principle Americans across the country can get behind. We've had these kind of rules in financial markets for nearly a century because we know what happens when intermediaries can rig a system. Competition is stifled and consumers lose. The same logic applies to real-time auctions for advertising, especially when it funds our news and information. As I recall, Chair Lee, you previously said, this is not a bill that's either liberal or conservative. It's not Republican or Democratic. It's just a good business process bill. Let's also remember the FTC's trial does begin in 2 weeks against Meta, aiming to unwind Facebook's acquisitions of Instagram and WhatsApp, and that DOJ filed a major antitrust case against Apple last year for abusing its App Store control. So we're finally seeing movement, but these things take years to resolve in the courts. That's why we need Congress to act now to bring some urgency and fairness into this market. The America Act is a first vital step to make sure the most powerful players follow some basic rules. That will give real businesses a shot and help quality journalism not just survive, but thrive. Thank you again for your time and your leadership. I look forward to working together to restore a fair marketplace.
Thank you so much. Ms. Harper.
Chair Lee, Ranking Member Booker, Senator Welch, members of the subcommittee, thank you for holding this hearing. Here's my thesis. It's stark and bracing, but the evidence supports it. Big tech firms have become too big to govern, and their power threatens our children, economy, and national security. These companies need to be broken up and their leaders held personally accountable for the lawlessness they have unleashed on American society. Since the founding of the American Economic Liberties Project in 2020, we have investigated the extraordinary economic and political power of the big tech companies Google, Meta, Apple, and Amazon. Their harms are well documented, but I'll mention just a few to emphasize the risks of their sustained market power. Amazon has allegedly sold suicide kits to teenagers. Meta knowingly allowed children to be bullied, harassed, and sexually solicited. More recently, Google's AI model threatened a college student, telling them they are, quote, a waste of time and resources, a stain on the universe, and urging them to, quote, please die, please. Small businesses and consumers also suffer under big tech's power. Sellers on Amazon pay up to 50% of their revenue to sell their own products and are forced to use Amazon's fulfillment services to access Prime customers. Small businesses disappear from Google search results for no reason, causing sales to plummet. And Apple has squeezed small developers creating innovative apps that want to reach consumers. Big tech firms also suppress speech and deplatform users. Google has been accused of kicking Reddit, podcasts, and other apps from the Play Store for no reason. But rather than fixing these harms, too big to govern firms instead thwart the law and make their own rules. Meta has repeatedly violated an FTC consent decree to protect children's privacy. Google General Counsel Kent Walker instructed employees to delete messages to evade the DOJ's lawsuit. And as members of this subcommittee know all too well, the big tech firms spent over $200 million in lobbying and ads to kill congressional efforts to regulate them. More recently, big tech CEOs have contributed hundreds of millions of dollars to President Trump as they all face federal lawsuits that could change their business models. Only remedies that reduce the too big to govern firms' power can end this lawlessness. And as today's panel of witnesses reflects, bipartisan consensus exists for these solutions. The most important remedy is not more fines or investigations, but holding executives of these companies personally liable and breaking up their monopolies. Remedies must be structural to eliminate conflicts of interest and behavioral to prevent firms from engaging in specific anti-competitive conduct. DOJ enforcers from both political parties have taken this approach to remedy the Google search monopoly. They're recommending structural remedies like a Chrome divestiture and behavioral remedies like banning Google from being the pain to be the default search provider on mobile devices. The framework also prevents Android from self-preferencing on Google search, an idea straight from Senator Klobuchar's bipartisan American Innovation and Online Choice Act. Only this type of aggressive regulation can unlock innovation in the internet search market and create space for platforms that safely cater to teenagers instead of abusing them. Most importantly, the DOJ framework does not rely exclusively on behavioral remedies, which too big to govern firms can easily work around, just as Apple has done after a court order to let app developers use different payment platforms. Momentum in the courts, however, is no reason for Congress to slow down. Senator Lee's Bipartisan America Act would separate publisher servers, advertising networks, and the exchanges. DOJ's case could end Google's monopolization of digital advertising, but Congress can act today and provide an immediate lifeline to journalists, publishers, and advertisers. Congress should impose structural and behavioral remedies across all the markets in which these firms operate. To maintain their chokehold over the US economy and democratic life, too big to govern firms will claim their dominance is necessary to compete with China. Ignore them. Increasingly, big tech firms are not producing cutting-edge innovation, especially in AI. This includes Apple, who couldn't debut a long-promised live demo of a generative AI product. And China-based DeepSeek's AI model highlighted the potential limitations of big tech's computing-intensive models. Tech monopolists falling behind, though, should come as no surprise. In the 1970s, enforcers had to break up AT&T to unleash innovation that created the modern internet. By contrast, Europe and Japan protected their tech national champions and watched US firms pass them by. Today, America and this subcommittee face a similar crossroads. Either make marginal changes and too big to govern firms will maintain their power, continue seeding lawlessness, and oversee US technology's decline, or break up these giants, restore the rule of law to increase competition, keep our children safe and our nation, while improving outcomes for workers and businesses of all sizes. The public is increasingly skeptical government can deliver. No half measure will do. Break them up. I look forward to your questions.
Thank you, Ms. Harper. Mr. Bazbaz, you're up next.
Chair Lee, Ranking Member Booker, Senator Welch, Welsh, and esteemed members of the committee. Thank you for this opportunity to speak on this critical issue. My name is Camille Bazbaz. I'm a Senior Vice President of Public Affairs at DuckDuckGo. DuckDuckGo was founded more than 15 years ago. We're based in Paoli, Pennsylvania, far outside of Silicon Valley. We offer a search engine like Google and a browser like Chrome. But unlike Google, we don't collect any of your search or browsing history. Our privacy policy can be summed up in just 4 words. We don't track you. We believe the best way to protect your privacy is to not collect your personal information at all. We compete directly with Google. We are the 2nd largest search engine on mobile devices in the United States and 3rd largest overall with a market share of about 2.5%. By contrast, Google's market share is more than 90%. The question isn't whether Google is a monopolist. In August 2024, a federal judge ruled that, in fact, it is. The question now is, what do we do about it? In American antitrust law, courts play a critical role, but Congress has a key role to play as well. Reining in big tech's abuses require overlapping and interlocking rules that allow for the freedom to innovate, the freedom to compete, and the freedoms for Americans to pick the services they want to use. As the title of this hearing states, there is no one big fix. There is no silver bullet. Restoring the free market requires multiple big fixes working together to undo more than a decade of illegal behavior. On March 7th, the U.S. Department of Justice submitted its revised proposal to remedy Google's anti-competitive behavior as the search case goes into the remedy phase. We support this proposal. While we recognize the potential of this landmark proposal, we must also recognize that the search market remains frozen in place, and it could be many years until anything changes. Despite public scandals, botched rollouts, widespread discussion about declining search quality, and the explosion of AI chatbots, Google's illegal stranglehold on the market and resulting market share remains unchanged. It should not take more than a decade of illegal behavior before action is taken. It should happen much faster. This is where Congress comes in. Building on the momentum of the Google search case, Congress can implement pro-competitive reforms that ensure companies like Google cannot decide for you what services you use, cannot block competitors from reaching consumers, and cannot self-preference their own products at the expense of better options. Congress has done this before. For example, the Telecommunications Act of 1996 forced the baby bells to license their infrastructure and work with competitors. This legislation not only unleashed more than $1 trillion of investment, it also forced incumbents to innovate and compete for consumers. The same can happen in the search market. Google has the most robust index of websites on the internet, but they only rank them one way in their search results. That means there's only one algorithm deciding and ranking the content that 90% of Americans see. It doesn't have to be this way. If competitors had access to that same index and anonymous ranking signals, they could launch new search engines with new algorithms and different ranking decisions to better serve consumers than Google is now. This kind of algorithmic choice and diversity isn't just good for business, but good for society at large. If you take away one thing from my testimony today, I hope it would be this. With congressional action, the search market can rapidly serve consumers so much better than it does now. Imagine a future where picking your default search engine is a choice you actually make, not one that's made for you by backroom business deals. Imagine a future where consumers can comparison shop between different search engines across features, benefits, rankings, and brands, easily picking the one that most suits their needs. For example, a search engine that favors small publishers or one that protects your privacy. We use search engines to ask some of our most sensitive and personal questions about life, parenting, politics, health, and everything in between. One company should not have a monopoly to answer those questions for 90% of Americans. We urge lawmakers to consider bold, clear, and targeted legislation that can change that. DuckDuckGo has supported antitrust reform efforts in the 117th, 118th Congress, and we applaud continued efforts like Senator Lee's America Act, which targets the conflict of interest at the heart of Google's digital advertising monopoly. I look forward to answering your questions.
Thank you so much. We will now proceed to alternating 5-minute Q&A sessions, alternating from one party to the other in order of seniority, subject to the early bird rule. Just for those here assembled, the hearing order I've got so far, Lee, Welsh, Moody, Durbin, Hawley, Klobuchar. And we'll add to that as others arrive. All right, so Mr. Kint, why don't I start with you? Tell me what some of the, what challenges do digital publishers face in navigating today's digital advertising ecosystem. Tell us about that.
Sure. Thank you for the question. So publishers today, I mean, advertising's about 80% of their revenue on the typical publisher in aggregate. So they're very dependent on advertising, for one, to pay for the high quality news and entertainment. And they have to deal with a marketplace that's been designed by Google, right? So Google gets to set the rules for auctions, and that's how most of the advertising gets sold. And the amount of money that Google's been able to take out of that supply chain consistently over years takes all the profits away. So publishers are not able to fund their news and entertainment.
And a lot of that stems, is it not, from the fact that they've combined the buy side and the sell side. So would a structural remedy of separating the buy and the sell side, would that make a difference? What impact would that have?
Yes. Requiring Google to not be dominant on the buy side and the sell side, simply put, and presented in the Justice Department's case, would radically change the future for publishers and news and entertainment companies. That the statistic from the allegations in court was that Google takes about 20% of the revenue from publishers in the typical auction. And the only way that they're able to keep that 20% over years is because they actually control the buy side.
Right. Something of a conditioned precedent for being able to do that. Professor Van Loo, let's pivot to you for a minute. Your research focuses on breaking up companies as a remedy, as a structural remedy. How would the America Act address and solve this problem specifically in the ad tech space?
It's clear that the America Act would require significant divestitures by Google and Facebook of some of their advertising businesses. And that would remove the current incentives for self-dealing and conflicts of interest that come from owning those various stages in the advertisement purchase process. There are a bunch of details that we could get into if you'd like, but at a high level of abstraction, in a sense, this remedy of requiring divestitures solves the problem that we would otherwise have if we let Google essentially keep a monopoly and then tried to require it to behave and regulate it heavily. And so one question you'd have to ask yourself is, do you trust or want to invest in our government kind of continually micromanaging whether or not Google is behaving and trust that they're going to be able to outsmart Google, so to speak? Or would you rather just remove those incentives at the outset?
Right. Now, your testimony mentioned that businesses from time to time will voluntarily break themselves up without anybody intervening. And you included examples that involved Hewlett-Packard and also PayPal, eBay. In April of last year, almost exactly a year ago, General Electric voluntarily split itself into three companies, marking the end of a vast corporate titan that was, once the single most valuable U.S. company. Since the breakup, in which we've seen it break up into three different pieces. You've got GE's energy division, now referred to as GE Vernova, and its shares are up 115%. You've also got General Electric Aerospace with its shares up 43%. So tell us how this happens and how a breakup can actually be a value enhancement, and thus benefiting both the business itself or themselves after the breakup and consumers.
Yeah, history suggests investors win and markets win because these companies are smaller, nimbler, they can innovate more, they can focus on their strategic advantages rather than being too big to manage. I think those are the biggest principles. I'm happy to say more too.
Now, does that matter? Are the salutary impacts, are the benefits associated with breakup, are they materially different depending on whether the company does it voluntarily or by order of a court?
No, that's a good question, but what we see is that historically after AT&T was split up, after Standard Oil was split up, there was tremendous innovation in those markets afterwards, tremendous growth, and investors also benefited. Now, I'm not going to say that it was a result of the breakup necessarily, but we see it on the voluntary side paying off, and we have no reason to suspect that it wouldn't pay off when government breakups happen as well.
Right. In other words, it's impossible to isolate all the causal factors in such a way that you can identify a clear line of causation between one another.
Yeah, you never know the counterfactual.
But there are at least a lot of correlative data points that suggest that it could be the cause.
Yes.
Great. My time's expired. We'll hear now from Senator Welch.
Thank you, and I'm delighted that we're joined by last year's chair of the Antitrust Committee, Senator Klobuchar. It's incredibly interesting. What you were just saying, Mr. Van Lex, is that the breakups actually can be beneficial to the shareholders as well as to innovation. So is there an outline of examples where that actually has happened that could be just a handy reference for us? You go back to Standard Oil. I mean, they're still doing okay, right?
Yeah. You've probably heard of Exxon and many of the other companies that resulted from that breakup. Yeah, and they've not only grown tremendously. By the way, it's also interesting that before those breakups, the company that's about to be broken up always screams bloody murder. No, you can't do this. It's going to mess up our operations. It's going to ruin the industry. And then lo and behold, that doesn't happen.
I want to just talk about something that's really simple, but just drives Vermont farmers crazy, and that's this right to repair thing. It's very simple in a way. And you've got a farm industry, you've got farmers who, if nothing else, can fix things because they have to, they can't afford, but they buy a tractor now and they are absolutely required to use the high-cost repair services of John Deere. Anybody want to address how in the world that's fair? Ms. Harper, you want to give me your take on that and how we could address that?
Yeah, well, it's not fair, to the short of it. And even though it's a different market area, I think a lot of the principles are relevant for this discussion of big tech. And the fact that there is litigation to address that and that FTC is looking into it is exactly like you said, one of the reasons why we need to make sure we have strong commissioners. But
well, it's like big tech in the sense that they have a dominant place. You buy your tractor, you know you're going to have to get repairs. You pay a price, a pretty hefty price to get the product, and then you're locked in if they use that pricing power, and also the fact that you have this tractor that's incredibly expensive and it's absolutely existential for your well-being as a farmer. I mean, in that sense, it's very similar to the pricing power, Mr. Kint, that you talked about with big tech, right?
And the loss of power for the farmer, and I think that's another consistent.
All right, just I'll ask Mr. Tan, if you would. The argument from the business that's created it is that this is our intellectual property. We figured out how to make this tractor, and we sold it to you at a fair price, but we've got now a computer program that you have to have in order, or we have to have and we pay for in order for us to fix it. So they justify their demand for payment, and that's the free market argument that many people in this House and Senate buy. But on the other hand, it makes powerless the farmer. Talk to me about that.
Senator, I'm less familiar with this particular situation, but where my head goes is ultimately what there should be in sort of desktop computers, for instance. There's a computer company called the Framework Computer that is an open and interoperable computer, and that's where my head goes. Competition is a pathway to giving people alternatives, and my hope is that perhaps this subcommittee could consider also.
Okay. Let me go to Mr. Van Loo.
Oh, please. Yeah, thank you.
I mean, the John Deere in this case, but it can be Google, it doesn't matter, name your company, is going to say, hey, we created this and don't bother us, okay? It's a fair price. But the consumer has literally no power, and in this case, a farmer consumer. What's the justification for saying there should be a right to repair and John Deere can't charge a person who fixes their own tractor?
The justification is simply that if the company can prevent you from going to alternatives for repairing that tractor or alternatives for follow-up services, that there's then a monopoly on the services. You're at the mercy of the business. And they offer so many different reasons why there shouldn't be access to repairs. They say privacy, oh, we have sensitive data in these cars, you can't repair cars because of that. They say intellectual property. These are pretexts for controlling information.
Okay, thank you. I yield back, Mr. Chairman. Thank you.
Senator Moody.
Thank you so much, Mr. Chairman. Appreciate the opportunity to address such an important topic. I think it may be one of the most important topics we're dealing with in America today. In fact, I appreciated each and every one of your comments. I thought it was very well-reasoned, insightful. I can tell you have been grappling with these issues for a long time. You know, it's hard, I think, for Americans that are benefiting in many ways in the use of technology in their daily lives. So over the last, let's say, 2 decades, technology has made each of our lives easier. I, for one, when I became the Attorney General in Florida and was still the mom of a school-aged child, said there's no way I could do this in a state the size of Florida in the effectiveness we were doing it without Amazon and Instacart, and I go on and on and on. It's ushered us into this century as a country prosperous. We've seen technology advance. In many ways, technology has helped this nation, and we are benefiting from that. Because of those benefits, I think we all expected more and more companies and competitors to emerge. And as we saw less and less of that over time, I think then that is when the concerns really started surfacing. And I have to thank you, Mr. Kint, for your comments. I know a lot of the folks on this subcommittee and, of course, the Judiciary Committee as a whole have been working very hard to make sure we are delivering not only on what information is available to Americans on how this affects consumers, but really deliberating whether we need new laws. And one thing that you said really resonated with me. You used the term gobbling up. And it's something that I have said, I call it the great gobble up. So we've gobbled up the ad tech markets, gobbled up little tech companies that were emerging and sometimes stifling further innovation there. We've gobbled up markets. It's gobbled up now independent thought. Companies have gotten so big, no one can argue that they are now gobbling up independent thought. In fact, as they are espousing to be town squares, they are at the same time deplatforming, shadow banning, stifling speech. And as this great gobble up has come to reality, we are now forced with, many of us have been working on this so many years. You also said it takes forever for the court to address one case. In fact, as AG, I led bipartisan cases. One of the first cases I worked on was Google. I could go on in terms of the actions we brought that we are still waiting to see resolution to the benefit of our citizens and specifically consumers. I think the frustration with courts and their delay is surfacing in many ways. I speak with my colleagues often about how we need to speed up court resolution of conflict and chaos, because that is what is guaranteed by this country, and only then can we, the people, trust that the structure of government is serving it. And I expect that we're going to see demands for more effective and speedy review in other matters. But what can you tell us, Mr. Kint, about that statement, that the frustration of the delay in courts, in many respects, justice delayed is justice denied? What can you say in terms of the need for immediacy for Congress to address this issue through policy and lawmaking, because enforcement through litigation has not worked?
Sure. Thank you for the question. It is immediate and profound, the need to move on this. The effects and a lot of the symptoms I've heard over the years that are all downstream, whether it be speech and potentially censorship of it, or privacy or disinformation, pick your your concern are all downstream from too much market power and gatekeepers, and they're very bipartisan. I mean, it stretches across the aisle, but the impact that's happening right now, particularly with our members, news and entertainment companies, is it's squeezing the lifeblood out of what funds news and entertainment. Whatever your preferences are as a consumer, there's not enough funding of it because all of the money and the control, whether it be the discovery, the data, the monetization, are all being gobbled up, to go back to that, by Google and Facebook and these market power players. And that's the issue. And so we need movement before we end up just suffocating them.
Just under.
Just under. You remain one of the most prompt members ever to serve in the United States Senate. Maybe
high
it'll prove
compliment.
contagious. Senator Durbin, you're up
And
next.
one of the newest ones.
Yes, exactly.
Thank you, Mr. Chairman. Great panel. It seems that this committee hearing is all about the elephant in the room, and all we're missing is an elephant. It's good to see and hear your observations on the state of play with Google at this moment. I'm trying to analogize this, and maybe I'm way off base, to what happened to AT&T in telephone service in my lifetime. Dramatic changes brought on by political forces, market forces, and perhaps innovation, all converging at once. Senator Klobuchar and I have been working together, and she's been a leader on this issue, and we have noted something interesting. When we went after child sexual abuse and had roll call votes on this Judiciary Committee with a spectrum of political thought represented, we ended up with unanimous votes for 5 bills. Unanimous votes. Let me tell you, as a politician for life, it was a shock. What we didn't realize was that wasn't enough to get the votes in this committee. Moving beyond that point meant taking on big tech, and we weren't very successful in that regard. So my question, stepping back for a moment, is whether this conversation about Google and its market dominance that was demonstrated by the committee is one that is subjected to market, political, or innovation forces that are going to lead to a change, even though they may be initially resistant. Any thoughts on that comparison? Professor Van Loo?
I'm optimistic right now, in part because the kinds of solutions that we're looking at in the America Act and beyond are going to help such a broad array of actors, not just consumers, but also small businesses. You have little tech that wants reform. You have even some of the CEOs of big tech calling for reform. Although I get that that might be, we can question where that's coming from. But so I could see for many of these reforms a coalition being built with strong political economy. I think it gets tougher when maybe all businesses are on one side and consumers are on the other.
So let me interrupt you, if I can, for a moment. I was involved in a battle, and still am, on the credit card side of the world between MasterCard, Visa, and the rest of the world.
Yeah.
Where they dominate when it comes to swipe fees, interchange fees. What we managed to do was to organize the retailers of America like never before. They all came together, big and large, big and small, and all argued they were being treated unfairly, and they were. We managed to engineer reform on the debit side, working on it on the credit side. Do you think consumers and retailers are sufficient organized force now to be an agent of change in Google?
Consumers, no. They need to be, or it'd be great to find a way to get them organized. I do think on the business side, you are seeing more organizing happening. And I think you have these models. Another model is when the internet was growing in the early years, Hollywood organized on one side and had exemptions to liability. So Section 230 it provided internet liability for platforms, but Hollywood said, no, not for copyright. We want to protect our copyright online. And so there are all these models, I like the one that you're pointing to with MasterCard, Visa, credit card companies that we can draw on right now.
Thank you. Anyone else have any thoughts on it? Mr. Kent?
I mean, the enforcement happening in the courts, and then I think legislation, starting with simple common sense rules like America Act, are critically important. None of these publishers, I work for some of the biggest media companies out there in terms of content creators, entertainment companies, and they can't negotiate on their own to the terms that would make sense. Google's too powerful. They control the discovery, the monetization, every aspect of how information entertainment gets out in the digital world. And so it's going to require more than just, certainly more than the consumers. There's not real competition. And I actually think the businesses themselves can't organize in a way to drive that change right now.
Thank you.
Senator Britt.
Thank you, Mr. Chairman, and thank you for all the witnesses for being here today. During my time in the Senate, I have made my concerns about big tech pretty darn clear, particularly as it relates to the impact of big tech and their business models and how that affects our children, largely looking at social media platforms. I also share some of my colleagues' concerns with the market power exercised by big tech firms and the extent in which they wield that market power in ways that stifle competition and erode public discourse via censorship of disfavored views. But I also know that we're in the middle of an ongoing competition with China for dominance in AI. And the Trump administration has made it very clear that it intends to keep the United States at the forefront of AI innovation. Obviously, many of the more established tech firms have been leaders in the development of AI in this country. However, we know that something has to be done about the things that I mentioned at the very beginning. So my question actually is for the entire panel. How do you think that we can best approach enforcement of antitrust laws in a way that effectively addresses the problem that we've seen with big tech, but that also doesn't undercut our position as the world's leader in AI innovation and development? And I'll just start here and we'll go all the way down.
I'm glad you're asking this question because I think it's important. There's often a misconception that by enforcing antitrust laws, we're going to hurt the American economy or hurt our ability to have big companies that compete internationally. I think it's quite the opposite, actually. We need to subject our own companies to rigorous competition here so that they are battle tested, so to speak, when they go abroad. If we don't, and they're insulated, coddled here, and then they try to compete on the international stage with companies that have in their own domestic industries been subject to intense competition, their products won't be as good. And so I think it's another one of those win-win situations where we enforce competition here, and in so doing, we set American companies up to continue being world leaders.
Excellent. Mr. Tan.
In my remarks, I mentioned Siri. Who here actually uses Siri? I personally do not, because I know that it does not have the cutting-edge technology that
I don't get along well with her. So
exactly that. And Anthropic or OpenAI or many other American labs could provide. And imagine if Apple opened it up so that, similar to when you open Windows, you have to choose a browser. Okay. What if you could choose your AI agent? Then there are 1 billion consumers in the world who would suddenly have access to not just one self-preferenced Siri, but a variety of American labs. And that would open up investment, that would open up prosperity.
And Mr. Tan, what you're saying is exactly what Professor Van Loo said, because then at that point, then Siri is going to be the very best, or since you have multiple options to choose, we're going to encourage our own producers to make better products.
Exactly. And instead, we are stuck with a Siri that will not have significant large language models for a number of years.
Doesn't understand my Southern accent.
I'll keep it simple. I agree with everything you've heard, and I would just add that as it relates to AI, which is much of the discussion right now, the evidence around Google that we saw in the courtroom during the antitrust trial and Judge Mehta's understanding of how important that was, including the remedies, has been very clear that we need competition in the AI world, and basically allowing a $1 trillion company to continue to be a monopolist in order to abuse that is the last thing we should be doing if we want to compete with China.
Absolutely. Ms. Harper.
Yeah, I agree with a lot of what's been said. I would just add that actually the monopolist often has an incentive to stifle competition. So Google had large language models but withheld them because they couldn't figure out how to integrate them with search and not threaten how much money they were making off of search. And so really, again, the key is to use enforcement to unlock competition, to force companies to have other companies that might emerge that have more sophisticated technology to keep America competitive. Because the reality is we're already losing.
Absolutely. Okay.
I'll just add that, just trying to put a fine point on it, is competition creates innovation. And if we can't compete with Google, or if others can't, then we're going to have the same products and they're going to get worse, is what we're already seeing. In the Google search case, evidence made clear that Google was well aware that they don't offer their users the same kind of privacy protection that DuckDuckGo does, and very clearly said that, we don't actually think that this is a big deal because no one's going to leave. And so we don't have to offer our users more privacy. We're not actually facing competitive pressure. That's somewhere where we could have seen more innovation and consumers lost out in the end.
Look, I'm out of time, Mr. Chairman. Certainly have more questions. I'm going to submit those for the record. It's critically important that we tackle this right now. I think that our future and the next generation are depending on us to do it. So thank you.
Thank you, Senator Britt. We'll hear next from Senator Klobuchar.
Thank you. I'm just, holding back the urge to take over the gavel after our many years together.
No, it's like a well-worn pair of shoes for you. Right?
There you go. Well, thank you, Senator Lee and your staff, Senator Booker and his staff, as well as Senator Welch, for putting together this great hearing. I just want to start with you, Mr. Bazbaz, because I think your company and others there are just a kind of a remedy of all of this: pro-competition, pro-entrepreneurship. It just shows how enforcing the antitrust laws and having them exist and knowing that they're out there makes a big difference. To me, it's pro-consumer and it's pro-capitalism. And that's why you see such broad political support and interest in all of this, and sometimes frustration that we haven't been able to move some of this legislation because of lobbying that I think actually would have been better for the companies in the first place. We want these companies to exist. We just want a fair marketplace. And so now we're coming at it a different way. And having prevailed in its case to challenge Google's monopoly in the online search market, in which Google controls, as we all know, more than 90% of search queries, the Justice Department has asked the court to stop Google from self-preferencing its online search product within the Android system. This remedy mirrors the prohibitions on anti-competitive self-preferencing that's actually in the bill that Senator Grassley and I have, that the company has spent hundreds of millions of dollars against in advertising. How does Google's self-preferencing of its search product within its Android operating system, which runs on more than 40% of the smartphones in the US, cement its monopoly over online search?
Thank you so much, Senator, and appreciate everything you said. Google's, on Android devices, it takes more than 10 steps to change your device default search engine. There is no setting on Android devices that just says search engine. It's buried among many different settings and many different apps. As I think other folks on the panel would agree, tech companies are usually really good at designing user interface and settings, and if they want you to click on something, they know very well how to do it. And the opposite is also true. If they don't want you to click on something, if they don't want you to be able to do something, they know very well how to put that together. So, we believe that the sort of self-preferencing on Android is the primary thing preventing Americans from having more privacy and picking DuckDuckGo.
Okay, thank you. Mr. Tan, are there other areas within its business that Google is able to self-preference its own adjacent products that the court should consider addressing so that small companies like Y Combinator can compete and innovate?
Absolutely. At Y Combinator and speaking for little tech and startups, we're not asking for a handout. We're not asking for privileged access. We actually want equal access. We want a fair market and a seat at the table to provide choice to consumers. And there are some significant areas. Other senators today mentioned their interest in child safety online. One of the requests for startups I put out on my X feed recently was a request for startups for alternatives using AI to replace YouTube Kids. And one of the things that we discovered is that there are actually Google policies that close this market to new entrants. Startups are actually barred from releasing such an alternative. And as an investor, it is not possible for us to invest in companies that are barred from markets.
Okay. Thank you. Mr. Kint, one harm from Google's monopoly, Meta's monopoly, has been a fall in advertising revenue for news publishers, plummeting from $37 billion to less than $9 billion from 08 to 20, with 1/3 of the newspapers closing since 05. We have areas that have news deserts now. Meanwhile, Google reported more than $72 billion in ad revenue in just last quarter. You're aware of the bill that Senator Kennedy and I have that advanced through this committee in 23 on a 14-7 vote. AI, of course, can make this even more problematic if things are stolen and stories are stolen and we don't have any kind of procedure in place. Why is it so important that this and other remedies to protect news publishers are adopted by courts, and why is news content so valuable to platforms such as Google? That's a softball.
Thank you for that question. The fixing of the problem that there's really no bargaining power for news publishers was I think germane to your bill, and I think it's really important to the remedies that are on trial in a few weeks for Google search. And I see a lot of actual inspiration in those remedies from the work that you and the committee did. It's critically important. I think we all understand the value of a free and plural press. The ability for Google not only to control the discovery, but to actually absorb all of the data from news to both instruct its search engine, both how the queries respond, how the clicks are able to be recorded at scale that nobody else can touch, is critically important to its discovery engine and to the future of AI. And that came out in the courtroom too. There's like 15% of the queries on Google every day that have never been seen before by anybody. They're completely new keywords that have never been entered in a prompt before. And Google knows how to respond to those better than anybody because they have the context for that query and they get it a lot of times from news publishers and they don't pay for it. And that's a problem.
Thank you. And I'll have some additional questions on the record for you, Ms. Harper, and you, Professor. Thank you very much.
Thanks, Senator Klobuchar. Senator Blumenthal.
Thank you to you, Mr. Chairman, and to others involved in organizing this hearing, and to all of this excellent panel. Similar to the search and advertising monopolies that we've been discussing this afternoon, Google and Apple dominate the mobile market. Both use the same anti-competitive tactics in mobile: self-preferencing to exclude competitors and monopolistic rents that raise the prices on consumers, as all of you well know. Senator Blackburn and I are the sponsors of the Open App Markets Act, which would set fair, clear, and enforceable rules to promote competition and strengthen consumer protections within the mobile marketplace. Those rules include opening up alternative markets, interoperability requirements, and guardrails on self-preferencing. I think some of you at least may be familiar with the Open App Markets Act. We plan to reintroduce this legislation soon, and we hope we can move it alongside Senator Lee's America Act and Senator Klobuchar's legislation, which we've been discussing today. So let me ask Mr. Tan, I appreciate your testimony today with your recommendations that closely track the Open App Markets Act. Every time Congress attempts to legislate in this area, Kids Online Safety Act, COSA, or any of the other proposals we're talking about, we see millions of dollars from big tech go into lobbying, whatever it may say publicly. Oh, we welcome regulation. We like your approach. Behind the scenes, often it will throw its weight against these kinds of consumer protection measures. As someone who works with startups, maybe you can speak a little bit more about how Google and Apple's mobile monopolies hinder investment and growth.
Absolutely. Thank you so much, Senator. And thanks for your leadership on the Open App Markets Act. We've had multiple experiences with app stores self-preferencing and using its ability to remove apps from the App Store to actually prevent people from getting access to other alternatives, Beeper being sort of the most egregious version of that. Apple took 3 days after Beeper Mini was launched to shut it down. It was actually providing real utility to Americans and consumers around the world because it was actually allowing encrypted communication between Apple iPhone users and Android users because encrypted RCS was not available yet. And yet Apple themselves did actually turn off Apple Mini after 3 days. And Apple themselves recognized how bad this was. They actually subsequently and directly after turning off Beeper Mini added encrypted RCS chats, which now you can see in your iPhones today. But they had kept iOS users exposed for months previously. So a remedy there would allow for open API and third-party clients to interact. And I believe your OAMA would be a huge step in the right direction. Thank you so much, Senator.
Thank you. Last session, Senator Hawley and I, as part of the Judiciary Subcommittee's work on technology, held several hearings on AI. And what was striking to me was that it's the new startups that are making the leaps in technology and innovation, not Google and Apple. Should we be concerned that monopolistic controls over mobile could hinder companies in innovation in AI or other areas?
Yes, I think that there's rampant self-preferencing. People are using their existing market power, whether it is in devices or operating systems or browsers, to prevent distribution and to self-preference their own options over those of competition, and the loser is the consumer. And it is also, the loser is also startups and startup founders. As an investor, we're not able to invest and help create prosperity where there is no access to free and open markets. And so we very much thank your efforts to protect that.
The losers are consumers, the losers are startups, the losers are new businesses. The real loser is America, because we will be falling behind our competitors in the world, whether it's China or other countries. Will be falling behind our peers in the defense sphere. And so the constriction of competition in these areas, I think, has very broad ramifications for our national defense as well as consumers and others. So this is an excellent panel. I wish I had more time, but thank you all for being here today and for all your work. I look forward to continuing our work with each of you. Thank you so much.
Thanks, Senator Blumenthal. We'll now start our second round. And Mr. Bazbaz, if it's all right, I'd like to start with you. Can you just explain for us the connection, as you see it, between online search on the one hand and digital advertising on the other hand, and then describe what those markets might look like if they were more competitive than they are?
Yeah, so just for context, DuckDuckGo, we are an ad-supported business. Our ads are contextually targeted, not behaviorally targeted, so they are targeted against keywords. So if you search for Jeeps, you get a Jeep ad. It's not based upon the last 20 searches you did or what someone else in your household searched or your device or anything like that.
What about your demographics?
Not based on your demographics. There's none of that behavioral targeting based on the person that goes in. And so if DuckDuckGo were to become more popular, more advertisers would be interested in that kind of advertising and reaching that customer. And so it's another situation where innovation would benefit Americans.
Great. Thank you. Mr. Tan, you come at this from a somewhat unique perspective, unique certainly within the room as an investor. Tell me how big tech may have stifled new innovative startups from your vantage point as an investor.
I think the biggest example is just clearly there can be no market when there is no access. In my opening remarks, that was one of the more remarkable examples of smart technologists who have PhDs, deep research in the ability to solve a real deep societal problem, and yet without access to the underlying systems, whether it's the phone or the operating system or at the carrier level, there is no way for smart technologists to actually solve these problems. And this is a company we did fund. They had to change their idea to a totally different one, and the world lost that gift.
Right. What are some of the other ways that startups can flourish other than being bought up by big tech firms?
The ideal for us, and certainly the many examples that we've seen include Airbnb, Coinbase, DoorDash. Some of the best startups of a generation came through, and they were able to do that by creating brand new markets and brand new networks. And so, I think that's really whether it's your legislation with the Americas Act and others, what we're hoping for is again brand new free markets where new entrants can come in, and that there is not self-preferencing, that the different parts of the marketplaces are actually able to create prosperity.
Right. So in some of the examples that you referenced, you're referring to companies that offered a new innovative service, filled a niche not being met elsewhere, and then stood by being a startup rather than just looking at being acquired. And that seems to be a magic formula of sorts.
IPO is a great way to exit.
Right. Mr. Kint, how do small businesses benefit from having multiple choices among competing digital platforms?
Platforms themselves, they can actually, in the case of, think about the app stores we were just talking about with Senator Blumenthal, they take 30% of the revenues, Apple or Google, on those app stores, and it's always been 30%. So driving down that price because there's multiple options for new developers is significant. Back to the America Act, being able to actually choose different ad servers. Google has 91%, according to the court evidence, of the ad server market for publishers. 91%. You have to use Google's ad server. There's no other choice. And so you're stuck with the rates and the rules, which involve a lot of your data being absorbed and a lot of your money being absorbed as a publisher.
Thank you. Professor Van Loo, how would the transparency requirements help create competition and protect it?
The transparency requirements, especially as they're designed in the America Act and should be designed elsewhere, are important in the sense that they require the handing over of information that either consumers or their third-party helpers might use to figure out what the best deals are in the marketplace. And so one of the ways that this unlocks innovation is that there are many third-party tools that want to help consumers right now that can't do it because they don't have access to the social media websites or to the APIs that feed the price and product information. And indeed, sometimes these companies have gone to court to shut down these startups that are trying to help consumers find better deals and to protect consumers from exposure to toxic social media.
Right. Thank you. All right. Senator Hawley just arrived. Why don't we go to him since this is still round one for him? You're up to bat. Thank you.
Thank you so much. Thank you, Mr. Chairman. Thanks for holding this hearing. Thanks to all of the witnesses for being here. Ms. Harper, if I could just start with you, I want to thank you for the great work that you do on antitrust enforcement. We've worked a lot, your organization, my office, so thank you for everything that you do. And something that you are very focused on is revitalizing antitrust enforcement, because revitalizing antitrust enforcement is really about protecting our markets, promoting competition, and getting a good result for consumers and workers. Is that fair to say?
Very fair, and other businesses as well.
And other businesses as well. Yeah, well said. Let's just talk, though, about some of the barriers to antitrust enforcement, effective enforcement. This is something in just my short time in the Senate that I've seen over and over and over again, is that antitrust suits that you would think should be brought don't get brought by the government. Suits that you think should be pursued don't get pursued. So can you speak to some of the barriers to effective antitrust enforcement that you see out there that you're familiar with?
Well, I mean, I do think big tech is an area where we've been quite impressed with just the wide range of suits that have been brought by enforcers and bipartisan enforcers across multiple administrations at this point. And that's encouraging and something that we've already discussed a bit today at the hearing. But usually what is most challenging for enforcers is having enough resources. I mean, these guys are often outgunned by the big tech firms that have unlimited budgets. The former chief legal officer at Google said publicly that they had about $1 billion to manage any sort of legal risk that was presented to them as a company. And we have enforcers that even in these trials will have about 1/10 of the resources that any individual defendant that they're taking on might have. So put all of that on turbo speed when it comes to big tech, and the inequity in resources is quite stark.
Yeah, that's startling. $1 billion, and that's versus government enforcers who have the resources of the government. I noticed that in the Clayton Act, anybody who's familiar with our antitrust statutes knows this, the Clayton Act, 15 U.S.C. Section 15A, the statute says that any person, I emphasize any person, who shall be injured in his business or property by reason of anything forbidden in the antitrust laws may sue, therefore, in any district court of the United States. That's a private right of enforcement. I mean, so the Clayton Act allows private suits, and yet it's usually, there are private antitrust suits out there, but usually it's government suits that we see. Is that because of the resource imbalance, do you think?
Yeah, I mean, it can be difficult to find a plaintiff's attorney that's willing to take on the risk. And again, when we're looking at bringing a suit against big tech, you are taking on not just the biggest giants of the United States, the biggest giants of the world that have unlimited resource. That can be quite intimidating for anyone who's running their own law firm.
Absolutely. Mr. Bazbaz, let me just ask you in this respect, your company has suffered, I would say, maybe more than anybody at the hands of Google and their anti-competitive conduct. Did your company bring an enforcement suit, a private enforcement suit under the Clayton Act? And if not, why not?
No, I don't believe we have. As we were just talking about, it's very resource intensive and time intensive. And, as a startup and, over our 15-year course of existing, you have to make trade-offs. We're trying to run a profitable company, which DuckDuckGo is. And so we're not just trying to raise more and more money and build up more and more equity and debt over time. And so you have to sort of pick your battles a little bit. And so that's not one thing that we've prioritized.
Yeah, that makes total sense. And I'm sure it's an entirely rational decision on your part. Here's where I'm going towards. Here's what I'm getting at. I just wonder if it's time that we took a little bit different approach to antitrust enforcement. I wonder if it's time that Congress, in addition to pursuing some of the other goals and goods that we've been talking about today, I wonder if it's time we revisited the power of private suits in antitrust enforcement and began to make those viable again. Courts have closed down access by private parties to antitrust enforcement suits by imposing injury and standing requirements that I think, frankly, are somewhat suspect. We could fix that. We could allow class action suits in the antitrust context. We could open up the courtroom doors and allow private parties access in such a way that it would make economic sense to bring a suit, and you'd have a better chance of prevailing. I just wonder if it's time we start thinking outside the box a little bit, or maybe it's not outside the box. Maybe it's getting back to first principles, because this is, after all, how the Clayton Act was written. I mean, it was written to allow not just government enforcers, and we understand the importance of that, but it was also meant to allow injured private parties to get into court and have a real shot at enforcing the law and recovering damages, treble damages under current law. Maybe we ought to increase those damages awards. Maybe we ought to change some of the injury and standing requirements that the courts have imposed that I think, frankly, are not there in the text, the history of the Clayton Act. Did I see you raising your hand, Professor? I call on you.
Thank you. I was going to say where you were ending up, which is we need to increase the incentives and rewards for bringing these lawsuits. We have bounties in other areas, such as securities laws. We could bring that into antitrust. So, and that's good on both sides, by the way. It's good for incentivizing the lawsuits to be brought. It's also good for deterring anti-competitive conduct because the penalties are greater.
Yes, exactly. Terrific point. Terrific point. And there's something that is, I think, particularly market reinforcing about private suits, because you have private actors who in real time are responding to harms. If they are properly incentivized and able to get into court to enforce their rights, that's good for the company. That's good for all of the other people who are in a similar position. It's good for the government, because the government is not expending resources. It's good for the market. As it turns out, the people who drafted the Clayton antitrust law were pretty smart, actually. They had a good intuition 100 years ago, and maybe it's time that we made better on that promise. Do you want to say something, Ms. Harper? I'll give you the last word.
I was just going to add, I mean, one, I love the creativity of different ideas of how we can take on the power of big tech. I think it's an all hands on deck situation, and every approach that we can adopt, we should be to stop their lawlessness. I will just add, though, and we hear this from a lot of market players, that it can also be quite scary to take on that public lawsuit for fear of retaliation. We know it's happening behind the scenes, but once you become the named party in a lawsuit, that can also heighten quite a bit that risk. And so I do think it's a both and, funding the antitrust enforcers, making sure they have the resources to bring these suits on behalf of a lot of the businesses who can't for themselves, but then also encouraging private suits as well.
Yeah, absolutely. I agree with all of that, and that's absolutely correct. I think absolutely correct. I'll just end with this. It's a point I've been making recently in other contexts, but there is something that is uniquely attention-grabbing to these companies about facing a jury, having to face a jury maybe and with a competitor who's sitting on the other side of the table and facing a judgment that will run into the billions of dollars. I mean, it really gets the attention of these CEOs and frankly their shareholders. I remember the FTC fined fined Meta not that long ago. It was a pretty large fine. Meta didn't meaningfully change their conduct. Their stock price went up the next day after the fine was announced. I mean, it's ridiculous. How would they like to face like a billion lawsuits that could run into damage totals of tens of billions, hundreds of billions of dollars? I don't know. Seems like that was the intuition of the drafters of the Clayton Act. I'm way over my time, Mr. Chairman. You've been super patient. Thank you.
Thank you very much. Good to have you with you. Senator Welch, we'll turn it back over to you. Thank you for...
well, no more questions, but just a comment. First of all, it's wonderful to be on this side of the dais and listen to people who are so informed, so engaged, and so committed to competition. So I just want to express my gratitude. And also, I just want to make a comment too, Mr. Chairman. There is so much bipartisan support for competition here. It is on us to get some legislation passed this year. And this should be independent of what other drama is going on in the Congress. This is about competition that's going to help folks, whether we're in a red state or a blue state. And also, Senator Hawley, we heard a lot of support for right to repair here. And I know that's near and dear to your heart and mine as well. So my hope, Mr. Chairman, is that we actually can move some legislation out of this committee and onto the floor. Because we've got a real strong basis of intellectual support for what we're doing and legal support. So I thank you, Mr. Chairman, for the hearing, and I thank our witnesses for the job very, very well done. Thank you.
Thanks so much, Senator Welch. Yeah, no, that's an excellent observation and aspiration, I think a realistic one. There are plenty of times where the parties are at odds with each other on deeply philosophical terms, and that may result in the appearance, if not also the reality, of obstreperousness on both sides of the aisle. Fortunately, this is not one of those areas. We've had a lot of kumbaya moments today in terms of our common aspirations, our common goals of making sure that we have adequate competition. It's not against the antitrust laws to be big. It's not against the antitrust laws to do a number of things. I mean, technically speaking, not even against the antitrust laws to occupy a monopolistic position in the market. But what is against our antitrust laws is acquiring or maintaining a dominance through anti-competitive means. And our job is to make sure that is working, that the marketplace is working, and that the marketplace is enabled, informed, and elevated by virtue of these principles, which sometimes with the advent of new technologies, we have to take another look. My overall angle on this has been that we don't want to reinvent the wheel too often because for the most part, our body of antitrust laws is a well-worn tool. So we ought to be looking for tweaks along the way made necessary by changed circumstances to the extent that they're there. And I think we've found some of those circumstances and certainly highlighted a number of those today. So I want to thank each of you. It's been an all-star witness. I've gained a lot of great insight and taken copious notes from each of you, and grateful to you for your thorough preparation. Written questions can be submitted for the record for this hearing until Friday, April 4th at 5 p.m., and I'll ask the witnesses to answer and return those questions to the subcommittee by Monday, the 14th of April at 5 p.m. Thank you very much. We stand adjourned.